Thank you. And today is Thursday, May 9th. It is 3 p.m. We are in the Greater Madawaska Township Council Chambers. This public meeting held under Section 34 and 45 of the Planning Act is declared open. The purpose of this hearing is to obtain public comments on the new draft comprehensive zoning bylaw and will be addressed in future council meetings. A minor variance application submitted under Section 45 will have a separate hearing and decision made on it immediately following this public hearing. We have members of the public here. I asked if you have any cell phones, if you could please put them on vibrate or airplane mode, it'd be greatly appreciated. Thank you. At this time, I will ask staff to please confirm that the required notice was given in accordance and requirements of the Planning Act. Kristen, please.
Thank you. I can confirm that the required notice was given in accordance with the with the requirements of the Planning Act. Thank you.
Thank you. All those present at the public hearing today will have the opportunity to comment on the draft comprehensive zoning bylaw. Any and all comments and information submitted, whether orally or in writing, including identifying information, become part of the public record and could be made publicly available at any point, including on the township's website and other electronic forms of publications in accordance with the Planning Act requirements. Before speaking, anyone providing comments is asked to clearly state their name and address for the record. And just to confirm that you have provided your contact information on the sign-in sheet with the recording secretary prior to or following this hearing. At this time, I will ask staff from EchoView to summarize any changes to the draft zoning bylaw and any new comments received. And
good afternoon, Mr. Mayor. Can you hear me?
yes, we can. Thank you.
Perfect. Okay, so good afternoon. My name is Jessica. I'm here from EcoView Consulting. This meeting is being held to present the final version of the draft comprehensive zoning bylaw for the Township of Greater Madawaska. The intent of this document is to repeal and replace the township's existing zoning bylaw in accordance with the Planning Act and the County of Renfrew official plan. This project has been ongoing since the township initially launched in November of 2021. Since then, EcoView has held various public consultation sessions and received and responded to a number of resident comments and concerns since then, which has now resulted in the document that you have in front of you. In addition, minor schedule amendments have been made and have been available for view throughout the public process of the zoning bylaw update. The draft that you have in front of you was last presented to council in 2023, which since then additional comments and public engagement have been gathered. The report that is on the agenda, which has been prepared by our office and signed by Kent, summarizes the minor textual and schedule amendments that have occurred since 2023. However, I can go over them very briefly if that is if council's wish. I can definitely do that. But I also have if there's any questions the council has or the public, I'm here to answer them.
I think at this time we'll ask, are there any members of the public who wish to provide comments on the draft bylaw at this time? Sir, if you'd like to come to the microphone and state your name and address, please. Yeah, there should be a green light there for you. And if it's not, oh, now it is.
Yeah, thank you. My name is Sam Baird. I'm from 328 Kennedy Road. Thanks for the invitation to make a few comments. I attended the previous public hearing on this, I believe it was last June, and also participated in the initial public meeting on this, which was in January 21. I met about 5 times with the previous planner on the comprehensive zoning bylaw plans and discussed progress with him on about 5 different occasions. And I met with both my wife and I met with the Kent, the lead writer of this document in 2022 we had a 2-hour meeting on the topic, so I'm quite up to date on it. At the last meeting, at the last public meeting in June, I did indicate that I was very happy, that I thought that an excellent job had been done, but at that time, I clearly indicated, and the record will show, that there was a few areas that I was still not 100% happy with. And I see in this version, those items haven't been changed. I'm disappointed, which is obvious, if in any public policy initiative, there's going to be people that are not going to be happy. I've got no problem with that. What I do have a problem with is the way this council has been running public meetings, and it doesn't seem to be, even if you disagree with the points that I put forward last year, I think I just didn't show up and give you a 5-minute discussion. Before showing up, I spent maybe a week going over and preparing for that meeting. And I made my presentation, I felt good about it. And even though I appreciate that you have to make decisions, you can't keep everybody happy, but I think in public meetings in a small town like Madawaska, at least we could acknowledge the amount of work that public put in. I never heard one word from anybody on all of the 5 items I discussed at the last public meeting. There was no discussion saying, Sam, yeah, we recognise you discussed that, and the reason it's not in and it's not going to be in is yeah. Because the problem is you draw me back and I go through the same damn thing all over again. So there's a couple of things I'd like to start with. I'd like, first of all, for you to go to page 28 of the document. Under the definition of high water mark. I don't know if Jessica wants to read out her definition, how that's written, or if you want me to read it, or how would you prefer?
Up to you, sir.
Because there's some people here don't obviously have the document.
Okay. How would I read it then?
So
I'll read the definition that's in front of us.
Okay, go ahead.
High water mark means the mark made by the action of the water under natural conditions on the shore or bank of the water, which action has to be so common and usual and so long continued that it has created a difference between the character of the vegetation or soil on one side of the mark and the character of the vegetation or soil on the other side of the mark.
Okay, so I think that's fairly clear. However, I think the average individual thinks of the high water mark as something vertical. Sure, it's vertical if you put a wall in front of it. If at the bottom of your wall is the low water mark and the water increases through spring runoff or whatever, that water will rise up that wall. So the actual mark between the low water mark and the high water mark is on the same vertical axis. We're not talking about vertical axis here, we're talking about horizontal axis, because the only way you would see a difference in vegetation would be horizontally. So having said that, now I'd like you to turn to page 46. And there's a set of drawings on page 46. If you give me a second to go there. So just take me a second here. Okay, on page 46, there's 3 scenarios of high water mark. If I could stand up and do a demonstration, Mr. Mayor, rather than, if this was a wall, if my property.
Just make sure you were picking up on the mic too, because this is being broadcast on YouTube.
Okay. In my property, I have a wall in my shoreline. Some people may not have a wall, some people may have a high bluff point, etc. So if the low water mark is where the floor is, and then we get spring runoff, the high water mark is in the exact same vertical plane because it's got nowhere to go, because I have stopped it, or nature has stopped it. So it's an incorrect way of looking at high water mark. If your high water mark is the point that you start to measure back your setback, it means you're measuring back from the exact same point as the low water mark as you do for the high water mark. So the way others do this, it has to be differentiated.
Just make sure you're getting on the mic, please.
Sorry?
Just make sure it's picking up on the mic. I didn't hear you.
So we have to think about this as the height that high water mark comes to on that wall. We have to try and relate that point horizontally. And that's where the high water mark is. So when we start to measure our setback, we don't measure it from here, we'll measure it from here. The high water mark is more landward than those people who have bluffs. If you go, for instance, to Steve Seaman's campsite, which is one of the most level places in the southwest corner of the lake, you can see the difference between his low water mark and his high water mark is somewhere around 40 feet, because it's flat as a pancake. That means that his setback is at 40 feet from the water. Because when the high water mark comes in the spring, that's where the water goes to. And that's not demonstrated in these definitions. So you might say, so what? So what is a really big deal, especially on the shoreline, because we want to have a further setback we can obtain as further back as possible for environmental reasons, as we know, and it's been well explained in here. All I'm suggesting to you is, if you go forward with this, I see a number of legal problems that you cannot talk your way out of. Because I could easily argue that the difference between somebody who wants to build, let's say, for instance, and you've seen it recently, you've had people at your variation committees and they've applied for setbacks to be reduced. If they come and they say that, like, what are they reducing it from? Are they reducing it from the point in the water that was their low water mark and is also their high water mark? Back landward. That means that building could be 10, 20, 30 feet closer to the water than it should be under the regulations, under your proposed regulations. Do you have an understanding of where I'm going with this? Is that fair? Okay, so I suggest that whole item under definitions may not form part of the bylaw, but it's certainly, I think, if you ever get to a tribunal situation, it's certainly going to come up there that's what the builder, the developer, that's how he or she has planned their various undertakings, is on the definitions in the current bylaw. So I asked that be looked at, that particular item be looked at. I think Kent probably took these drawings from some standard package somewhere. But I want to make sure that the council, and Jessica, I want to make sure that you understand what I'm talking about here as well, because it's going to be very difficult later when I walk away from here and you're sent to re-look at this item and you don't completely understand where I'm going with it. That's a question to Jessica through the mayor.
Yeah, well, this is being recorded, and Renee's taking notes, Kristen's taking notes, and Jessica's most likely taking notes. I can't see her hands, but she's nodding the affirmative that she is, so.
Okay, so one other item, and I must apologize, I forgot, I don't have my working notes with me. There's another item. It's based on setbacks, and we call it the slang planning word is we call it the established line provisions. In my 2-hour meeting, both Alana and I had with Kent back in 21, I believe, or 22, I think it was. We spent practically the whole time talking about the established line. For those that don't know what established line is, just generally, or roughly, I should say, the established line indicates, now, at the moment in this bylaw, you're talking about a 30-metre setback from the high water mark. That's how far you have to be back before you can build. However, if you have a house within 100 feet of you to one side and within 100 metres of you on one side, and another house within 100 metres of you on the other side, if they are closer to the water than the 30 metres, which would have been the provision from 20, 30, 40, 50, 60, 70 years ago, you can actually draw a line from one house to the other house, and that dictates that you have an established line. Those two houses have created a line. You as a new builder, if you're building in the middle of that, you can claim that line, meaning that you don't have to build to the 30-metre setback, you can build to that line. But the line, now, there is a minimum, and Kent did make a change to it, and I thanked him for that at the last meeting. But the bylaw also says that, yes, you can draw your setback forward, but it can't be any further forward than 20 metres. It used to be 15 metres, or I should say it's currently 15 metres. It's 20 metres is under the new bylaw. So that's what the established line is. Okay, so let's park that. Now we know what the established line is. Now, the whole reason for a comprehensive zoning bylaw, in the hierarchy of public policy, the federal government basically indicates to the province, this is what we would like you to do to contribute to Canada. And the province says to the county, okay, for me to deliver to the feds, I need the county to deliver this to me. So the county comes up with a bunch of bylaws and a bunch of operational plans that allows them to deliver to the province, to help the province deliver to the feds. And then below that, the county turns around, and the county doesn't have the vehicles to deliver at the local level, usually. The county turns around to the municipality and says to the municipality, okay, I want you to help me deliver the county operational plan. So the municipality comes up with their set of bylaws, their set of rules, and their mini operational plans to help the county do it. So therefore, and this is what's happening here, this is us creating a consolidated bylaw that will permit us to help the county to deliver their goals and objectives. There's a whole reason for this. Now, established lines were created back in the 50s, 60s to help the county deliver their goals. Right up to the previous operational plan before 2014, there was matters in the county's plan that they wanted to deliver in this way, and that's why established lines were put in place at the municipal level. Well, that demand is no longer there in the county plan, operational plan. So there's no need for us to have an established line provision in our bylaws because the county doesn't need it. We're not helping the county to deliver in their operational plans because that established line is not required under the new Renfrew County operational plan. You can check with Kent on this. As I said, him and Alana and I discussed this point very clearly for a two-hour meeting, and we both understand that. So that's why, and I spoke, what I've just told you a few minutes ago, if you'll recall, when I done the presentation to you last June, I said the exact same thing. But in this provision, in this version, there's been no change.
Mr. Baird, I'm just going to ask, I'm just going through the definitions here. And I don't see that an established line is in any of the definitions here, so I'm just trying to get to where you're
Okay,
pointing this out in the document.
Okay, it's not called the established line, but as I mentioned to you earlier, Mayor, I don't have my scribble notes. Okay, it's called something else.
Yeah, so for an existing lot of record situated between two existing dwellings, separated by not more than 100 meters.
And what page are you on?
It's something I copied and pasted. Okay, page 24.
Page 24, it's called established building line. I believe that's what.
Yeah,
Yeah, so it's what you were talking, should I read the rest, or is?
No, because this is what
Okay, all right, so we've got it.
so to answer your question.
Thank you.
So those, I don't want to go into any more minor details. Those are the biggie ones that I'd like to leave behind, and I thank you for your time, and I'll be willing to take any questions if anybody has any on those matters.
Thank you for your time, sir. Does anyone else wish to speak on the zoning bylaws? No? Yes? State your name and address, please.
Hi, I'm Peter Coulterman, and I was just concerned with two questions. One with Ken. I was questioning what kind of engineer he is. Is he an environmental engineer? Is he a civil engineer? I think that's important. We're talking a lot of different things that's going to go on with this new implementation of the laws here. Another thing is, if they're changing the regulations on gravel and what kind of testing have they done? Have they done soil testing? I know my property is mostly sandy loam, and they got it under gravel. What can it be used for? I mean, what kind of testing have they done before they're implementing this kind of change on where the gravel is and where it is? That's my two main concerns. Thanks.
Thank you. Jess, do you want to respond to that?
Absolutely. So through you, Mr. Mayor.
Thank you.
So the zoning bylaw would not be dealing with any placement of fill or any relocation of fill. The any site alteration bylaw that the township has would be dealing with that. However, if we're speaking about the aggregate zoning or anything related to the aggregate zoning, that is exclusively related to information that the county has provided through their official plan. So the, for example, the extractive mineral reserve zoning is a direct copy of the designation from the County of Renfrew official plan. We would not have included any additional lands, and we've not included any lands in addition to what the county has. So anything would have been confirmed by them, and we just put that forward. I hope that answers the question, but I can provide any more info.
Thank you. Hang on, sir. If you're going to ask a question, I just need you back in the mic because she wouldn't be able to hear you otherwise.
Okay, I'm not sure if I heard, did you say what Ken was, what type of engineer he was?
So through you, Mr. Mayor, he's not an engineer. He's a registered professional planner. So he's a land use planner.
Okay, thank you.
Thank you. Does anyone else wish to make comment? Yep, perfect. Thank you.
Hi, my name is Wilf O'Brien. I think first of all, not everybody has a cell phone here with all the information on it. It might be good when people come into the meeting, if what we're doing, if copies could be made to the people so we can follow along, so I can follow along with this gentleman like everybody else was trying, like Taylor was with his phone and so on. That's just an aside. The extractive industrial reserve zone was supposed to be expanded. Now I guess it's pulled back. It's not expanded as much as it was going to be. And that was information that was passed on to a couple of the people who had impacted. My question concerning some of this is, when these areas are identified, has it got anything to do with the township at all? Or is it all coming down from the province or all coming down from Renfrew County? Because when you make a phone call and you ask somebody, it seems that you're getting passed from one person to the other. And so, does the municipality have any input into these decisions? And what I want to go a little further in asking this, with the aggregates, most of it seems to be in Ward 2. When they're expanding the road as they did, and you did a beautiful job, the road was done. Years ago, and I've been here for 47 years now, I'm an old person, and the old township, and I can name you all the old councilors that were on it, when they were building a road or something, they used local gravel. I have a gravel pit in my farm. It's not a registered pit. I don't want to register it. I know there are things that you have to do. But 20 years ago when they were doing the road, they used the gravel from my pit. I don't need the money. I told them they could have it whatever they want and give me what they wanted for it. When they were doing the last zoning, I told them the same thing. I called the CEO here and I said, you're bringing in, it's not the cost of gravel. And my question here is, with these reserves, is what does the municipality have as input to some of these things that are being passed to us? Do you have any input? Or is everything mandated by the province and by the county? And I'll just give you an example. I do not want to be an elected official, so I thank you people for doing that. I wouldn't do it for all the money in the world. But one of the things I think with elected officials that I would like, and has to do with some of these things with the zoning and these aggregates, is if we have local aggregate, and we know we have it, as we see in this, why are those not being used? I'm not saying at my place. I'm saying down at Peter Colderman's place or someplace else. Do you want to tell me how much the road costs to build past 1356 Ferguson Lake Road and up through here? It's not the cost of the aggregates. What's the cost? It's the cost of trucking. Okay? What are we supposed to be doing in modern society? Environmental. So you've got the trucking. You've got the pollution. And you may say, well, Mr. O'Brien, that's not what we're talking about here today. Yeah, it is what we're talking about. So what I'm asking, in the future, if my kids build on our farm someday and they go to update things, does the municipal council have any leeway, any say that they can go to the county or the province and say, we're not going to truck stuff from 20 miles away and cost us a couple of $1 million more than if we bought it locally? I'd like an answer to that. Does the municipal council, and if you don't have any say, then that's fine.
So in regards to what you're expressing right now, it's more towards the actual zoning bylaw, correct? It's the usage of the aggregate from our area.
Yeah.
So when we are looking for aggregate or any building materials or any materials, we put a tender out. People who respond to that tender is how we make our decision. So if nobody from the area responds to a tender or is unable to do it, then we wouldn't address it. But if people need to answer tenders, and if they put a tender in, then yes, it will be addressed.
Okay, can I ask a question? We have people hired in council, road superintendents and so on, and I know I'm old. Okay, but back in the day, there were 5 councillors along the flat road from Mount St. Patrick when it was Brome Township. Okay, they knew where the gravel was locally. Okay, they didn't tender it. So what I'm saying is it council's responsibility to look at saving the taxpayer money. And if there is a way, then the road superintendent or an engineer or somebody should maybe look into that and could save us substantial dollars. That's all I have to ask. And I just wanted to make a point. I think the road is a tremendous thing. Roads in the future will be the same way. But if we have local sources, which have been used for 100 years, and we're talking about the environment and all these other things, let's save some money and let's buy farmers local. Get some aggregates and so on local. And if you put it out for tender, if that's the way, we have engineers that you hire, or the road superintendent, he should, if they can change the designation of this area, we're going to make it bigger, now they're going to make it smaller. Well, they've looked at where the aggregates are, Taylor. Okay, well, you know where aggregates are. And you don't have to bring it from someplace. Go and say to somebody, can we save the township hundreds of thousands of dollars? And I believe you can.
Okay.
That's my ranting and raving. I'm sorry.
No worries, thank you.
I wouldn't want your job for all the world.
Thank you for coming out. Are there any other members of public that wish to make comment on the zoning bylaw? There are none seen. I'll ask a second time. Anybody further comments? None seen. Third time. No comments. Fine. I thank you all for coming out today. Please drive safe. This concludes the public meeting portion of the zoning bylaw. Those here for the zoning bylaw are free to leave before we head into the Committee of Adjustment. Thank you to all of those who have provided comments. We appreciate the participation. Thank you. Thank you.